Hey friends, I am an expert estate planner. I've worked with thousands of families, and there's 3 things I would never do as an estate planner. 1, I would never just have a will in place. If you just have a will, you are exposing your family to 2 or 3 years of court battles. It's called probate. If you leave everything to your family and only have a will, it's going to be public, it's going to be stuck in the courts, it's going to be very expensive, and it takes forever. It's stuck in probate. Instead, you should have a living trust and leave assets to your family with the trust. It privatizes your affairs, keeps your family out of the courts after you're gone, a much better way to do things. It can save your family tens of thousands of dollars. 2, I would never leave anything directly to children or to my future children. What? You might think that's crazy. Disinherit children? No, I wouldn't leave anything to them. Instead, I would create trusts for them. If they're under the age of 18 and something happens to you, if you just leave assets directly to them, they're going to get control at 18. Usually a terrible thing. You want at least age restrictions, but better yet, you should create separate family protection trusts, or as they're generically known, dynasty trusts. This way you leave assets for the benefit of your kids, but you give protections against divorce, against lawsuits, and future estate taxes, and these trusts can last for multiple generations. Leaving assets to family protection trusts is how higher net worth families preserve assets for multiple generations and really build wealth. So don't leave anything directly to your kids, create protective trusts for them. 3, another thing I would never do as an estate planner, I would never add a child onto title for my home. A lot of people think, oh, well, that's a way I can start transferring title. I can help out my kid. Don't do that. In California, that can result in immediate and massive reassessment of property taxes. And that also means that your child may lose out on the crucial stepped up cost basis when you pass away, meaning capital gains taxes go away. If it's in your estate and goes to your kids after you pass away, they get the benefit of a stepped up basis. Capital gains taxes go away. If you add their name to title before you pass away, whatever portion they already own will not get that stepped up basis. You might be unnecessarily exposing them to capital gains taxes, might be triggering an immediate tax reassessment. And oh, by the way, if your kid is ever sued or has creditors coming after them and they're on title for your home could be at risk. So don't add your kids to title for your home unless there's a very good reason for that. So the 3 things I wouldn't do. I know it's a lot. How do you stay on top of all of this? Follow us, share, comment. Let us know if you have any questions about this.